All right. Last but certainly not least is our own Paul Dubbeling, who is here to present to us pressure points. What's likely to work and why? Paul, if you haven't heard his bio before, is a former U.S. Army Ranger and infantry officer. He attended law school on an Army scholarship, graduated summa cum laude from Indiana University in Bloomington in 2005, and earned his MBA from Duke University's Fuqua School of Business. He then served as a JAG attorney for 6 years in the Army, including 2 tours in Afghanistan. After leaving the Army, Paul clerked for Judge Neil Gorsuch. We've heard of him before, who is now Supreme Court Justice, before going into private practice. Then Paul successfully prosecuted Doe's versus Cooper, federal lawsuit which struck down most of North Carolina's previous premises restrictions, and is currently lead counsel for Narsol's legal challenge to the North Carolina registration laws, Doe's v. Stein. Paul is Narsol's attorney and one of our white knights in the court. So please welcome Paul to the podium now.
Thank you. Okay, we're good on the mic. This is odd because I'm actually reverberating loudly in my own ears and I'm not speaking loudly at all. And as some of you know, when I get excited, I tend to speak loudly, so we'll see how that goes. Okay. Also, we have great technology now, so I've been told to stay between the screens, but other than that, I should be free. Okay. All right, main themes today. One, I want to talk about the difference, and I think this is something that's hard for people to really accept because it's difficult, and that's that I'm talking about legal challenges. And legal challenges, of course, are different from legislative challenges. They're different from moral challenges. They're different from justice. And I think it's going to be helpful to tease those out. And there's an intersection between the law and what is right. There's an intersection between the law and what is moral. There's an intersection between the legal system and a hypothetical justice system. But as we've probably all come to know, dealing with registry laws on the paths that brought us here, they aren't the same thing. And I want to talk about what the differences are and what those mean in terms of a strategy going forward. I want to talk about the environment. And by that I mean I want to try and parse out, discuss, analyze the legal and human environment in which we're operating and what that means for a litigation strategy going forward. As I mentioned the last time I spoke last year, we just live in a quote-unquote conservative world. The Supreme Court is conservative. What that means is open to debate. To the different justices on the Supreme Court, it means different things. But conservative does have a meaning that impacts what we're doing. And I want to talk about what that meaning is, and I want to talk about what it means. And I want to offer you that conservatism places limits on the type of challenges that will be successful. But it also opens doors that weren't previously open for challenges to the registry laws. And finally, I want to go through a list of practical challenges. While I've been here in the last couple days, I've met with a number of local affiliates, I've met with registrants, I've met with parents, and people have been asking me, can we do a challenge? And that's going to be a very state-by-state, jurisdiction-by-jurisdiction, law-by-law question, but what I hope to do is give you things to look for. So when you go back to your state and you're looking at your laws, people are calling your offices and saying, this is what happened. You have some sense of, okay, is that something that in broad strokes might fit into a legal challenge? Is that amenable to a lawsuit? And if it is, if you have that little tingle go off in your head, hey, this is something we talked about, we want to explore that further. Because the challenges that we've done in North Carolina that we have ongoing, most of them start with somebody calling my office. Recently, well, in constitutional terms recently, last December, Narsol spoke with a man called me. I said, okay, what's the situation? And he said, I moved to North Carolina in 2004. I went to the sheriff. The sheriff said I didn't have to register. Then in 2017, a different sheriff literally knocked on his door and said, what the hell are you doing? Why aren't you registered? If you don't register, you're guilty of felonies. And he said, what do I do? I said, wait a second. Who told you you had to register? He's like, the sheriff. I'm like, well, well, why is the sheriff making decisions about who has to register? That's not a sheriff's question. Sheriffs enforce the law. Sheriffs don't decide how the law applies. And that case isn't done yet, but I feel very confident about it because we were before a quote-unquote conservative judge that said, Your Honor, the state can do this, but a sheriff can't. And the judge looked at me and said, yeah, that seems right to me, and then told the state to have dispositive motions in within 60 days. So there are things we can do. Okay, the difference between constitutional law and human rights, and this is one of the ways that you end up defining liberal and conservative. There just is. You know, the Department of Justice, the justice system, the Justice League, the Hall of Justice, whatever. But the point is that conservative jurists do believe that there is such a thing as the law. But the law and what is moral and what is right may or may not overlap. That's just reality. And it's very painful, I know, but I talk to people that say to me, you know, this is unfair. I'm like, yes, it is unfair. I completely agree. I talk to people who say, this is not right. I agree with them. But as a lawyer, there's nothing I can do about that, right? I have to be able to find what is illegal about what's going on. And this is one of the reasons why the project that we're jointly engaged in has to have two sides. It has to have the legal side, which is preventing the state from overreaching, preventing the state from crossing from bad policy, but legal policy, to illegal policy. That's the side that I primarily work on. And then there has to be a side where we're convincing the society at large and we're convincing legislatures that what is going on is unfair and not right. And those are related projects. They work hand in hand, but they are very, very much not the same. Not just that one involves the courts and one involves the legislatures. They're fundamentally different in what you're trying to do. As a lawyer, I'm trying to cabin the state. The state will overreach itself. The state will tell sheriffs, you know, we don't have any guidelines, but just go start knocking on doors. The state will continually pass new and more restrictive laws until someone says, you have crossed the line and that is illegal. And for those of you who I spoke with on Friday, that's one of the things I was trying to show you, right? There is a natural progression. The state, once it gets rolling, will keep rolling until someone stops it, okay? But I'm waiting for them to cross that line. I have to wait for them to cross that line from wrong-headed, pig-headed, bad public policy, immoral, wrong, to illegal. Premises restrictions, housing restrictions, a lot of that stuff. And I'm going to say probably because it very much depends on the specific circumstances, but there is a growing recognition that they are illegal. We can do something about that. But the basic problem of this idea that making lists of citizens and then using that list to ostracize them, categorize them, and limit their civil liberties, so far, that's not illegal. And that's a legislative issue, and we're going to talk about that. So when I look at a lawsuit, and this is difficult because, as some of you know, I can get very excited about things. I have to remind myself the question is not, is it wrong? The question is not, is this a good idea in public policy? The question is even not even does it work? Is it sensical? Is it logical? At some level, and lawyers in the audience, I hope you understand what I'm saying, at some level it doesn't even matter if it's rational, because courts will bend over backwards to let legislatures do things that are pig-headed, wrong, and even irrational if they don't see an overarching legal problem. So from the legal perspective, and only from the legal perspective, the only question that I'm asking myself is, within the existing legal environment, will my position prevail? Which is, because I'm a lawyer, I can take 4 words and make it 12. Will I win? Right? A legal challenge, that's the question, will I win? It doesn't matter if it's right or wrong from a legal perspective. It doesn't matter if it's good or bad. The question is, given what I'm facing as a lawyer, if I bring this challenge, are we going to win? Or at least do I think we're going to win? Okay. So what do I mean by the legal environment? One, I told you I meant conservatism, legal conservatism, and there are a bunch of aspects to that. Just like in the political world, when you call someone a conservative, you're implying a whole bunch of things that may or may not apply to the particular individual. But it has a meaning, and that meaning is fairly broad. And in the legal context, the one thing I want to focus on is conservatism means textualism. Conservatism means originalism, and these are related but slightly different things. Textualism means a conservative judge is going to look at you and he's going to say, Mr. Attorney, what word in the statute are you pointing to? Show me the statute. Don't talk to me, and I've had this happen to me in court, do not talk to me about how this is a bad idea. Do not talk to me about the injustice of it all. Show me the statute, and then show me where the person you're suing did something the statute does not allow. But there's a flip side to this, right? When the state asserts its authority, you get to turn around and say, state, show me the source of your authority. And for those of you who follow these things, I posit to you that that's what the Gundy case is about. The Gundy case, for those of you who don't know, is the current Supreme Court case where a registrant is challenging the idea that the Attorney General can decide whether the Adam Walsh Act or SORNA is applied retroactively. And as a lawyer, the issue there, frankly, doesn't have a lot to do with the registration issue. The Supreme Court did not take that case because it's sort of interested in registration issues. The Supreme Court took that case because it's interested in the question, who's making the decision? And we'll talk about this a little bit more later, but the Supreme Court, at the same time it's asking us to show them the statute, is asking the government to pull out the Constitution and show them where it says the Attorney General of the United States gets to decide to what population a law applies. So textualism, originalism, places limits on what we can do, but it also creates opportunities. And that's what I want to talk about today. Limits tempered by opportunities. That's what I was just talking about, separation of power, right? Textualism, originalism works both ways. Conservatives are concerned about who is doing it.
When you say suing, are you talking about suing for money or suing? I don't understand what suing means.
I'm sorry, so in my world, suing in this context means I'm bringing a lawsuit against the government, or the state government, the federal government, or somebody, for what's called declaratory and injunctive relief, not money. I'm asking a court to say, this statute is unconstitutional. I'm asking a court to say, you can't do this. That's the declaratory relief. And then injunctive relief is then to issue an order that says, and you can't enforce it. So in the North Carolina lawsuit, Doe v. Coopers, what the court said was 14-208.18, which effectively said, and there's a new statute that covers much the same ground, effectively said if you were on the registry, you can't be in any public place, essentially. The court declared that's unconstitutional and then ordered the state to stop arresting people for it. Now, does that work? Yes, ultimately, because now if someone were arrested for that, I would just show up in court, show the order, and say, this is illegal. And for reasons that are more complicated than now, at that point I also get to sue for money. If the court tells them not to do it, and then they go do it again, then we're suing people in the classic sense of the word. Okay, I want to talk about the political reality. And the point I want to make here is that courts use the language of objectivity. Courts, frankly, like to pretend that they are unaffected by the political environment in which they're operating. And sometimes, but often not. If you look at history, and this is another thing I talked about on Friday, if you look at the history of these things, courts tend to be deferential to the government when there's a related amount of hysteria and hype and political ill will and what have you. And I just put up some cases where that's true, and then a case on the other end where you see the opposite. But for those who don't remember, Korematsu is the Supreme Court case from the early 40s that validated the executive's authority to intern American-born Japanese during World War II. And I submit to you that that is crazy, right? that in the name of national security, you can take an entire population of people and place them in internment camps with no evidence whatsoever that they have anything against you or engaged in any sort of subterfuge. But in the context of the beginning of World War II, the court allowed that. Padilla was the American citizen who was held by the military. The government declared him to be an unlawful enemy combatant and then said he has no right to an attorney, to a trial, we can hold him as long as we want, and effectively we can do whatever we want to him. That is, of course, crazy. But in the context of the post-9/11 fear of worldwide Islamo-terrorism, the courts effectively punted. Now, ultimately, that case was dismissed on technical grounds. But the point is, the courts essentially waited 6 or 8 years before doing anything. What they would not do is the Supreme Court would not take what's called a writ of habeas corpus. And that's where you go to the court and say, this is wrong, step in now, do it quickly, blah, blah. They would not do that because, frankly, the court was concerned that if they did, they would create a constitutional crisis. We live in a society where we accept as Americans that the courts have this power, right? We do what the courts say. But the court is well aware that that is a very, very delicate state of affairs. I submit to you that when the Supreme Court ordered integration in 1960s, several southern states basically said, up yours. And that creates a situation where Black Americans are standing ready to go to an institution of higher learning that they have a constitutional right to go to. That is beyond doubt. It has been settled. And the question becomes, is the federal government going to enforce it? And when you talk about enforcement, ultimately, if it's not by consent, it is by people with guns. And that's how integration happened. We like to think Brown versus Board of Education, and I will talk about that in a second. But it really happened because the President of the United States told the National Guard, take your guns, go down there, and make this happen. The President doesn't do that. We have a problem. And it's not at all clear that the President will always do that. So the court is aware of the political environment it's operating in. Brown versus Board of Education, a flip side. In The Brethren, a book about the Warren Court, actually scratch that, not in The Brethren, but this is a true story. The court is looking at whether or not to overturn Plessy v. Ferguson, to say that the Equal Protection Clause does not mean separate but equal, that equal means the same. Seems self-evident today, but in 1954 would have been a sea change in constitutional jurisprudence. And the justices looked at that, and they knew it was right. They knew that it should happen. They knew that the United States was making a mockery of its own first principles. They also knew it had to be 9-0. It had to be a unified statement. It had to be a consensus. They had to come out in force and say, there is no doubt, there is no dissent, because of what they were trying to do. And remember, with 9-0, Brown versus Ward is 1954. School integration battles are going on 20 years later, right? That's a united court saying that. That's a federal government passing the Civil Rights Act. That is the federal court, the federal executive, Congress, and the judiciary united in making something happen. And still takes 20 years, and arguably still isn't complete. Political reality and adverse historical trends. And this is what I mean when I say that we live in a conservative world. In 1968, the Alaska case probably comes out differently, Doe v. Smith, right? In 1968, the Supreme Court probably says, yeah, the Constitution embodies a right to privacy such that, mass dissemination of undifferentiated information, even though public, violates that right. That there's some sense of a right to be forgotten that has been recognized in Europe. In 1968. Today, there's no chance, right? That's the adverse historical trend. The Supreme Court of the United States, for the last generation, has been slowly cabining the idea of unenumerated rights, has been slowly limiting those things that will be recognized by the court that aren't specifically in the Constitution. And that's an adverse historical trend where what you really want to do is get up and scream, this is just stupid and wrong, to which, as I mentioned before, the court is going to say, that's maybe true, but show me where it's illegal. So this all works together. And I added this because I also want to say, as I said before, that there are adverse historical trends also creates opportunities. Those trends say that we can't do one thing, but they suggest that we can do another. Okay. Textualism, originalism. What you've got to do to be successful. You have to answer the question, what is your textual hook? What is it that I'm claiming the government is violating? You have to point to the ex post facto clause. You have to point to the due process clause. And as I've become more attuned to this issue, there are lots of instances, I believe, where the problem is that the states have basically delegated all of this down to law enforcement officials who are making decisions about who's on the registry, how we determine whether one crime is like another crime, all of this. And conservative jurists are very interested in how decisions are made. They are very willing to say, it's not about an ultimate limit on power. It's about who has the power. How is it cabined? And that's what Gundy is about. No law abridging the freedom of speech, right? And hopefully you're saying, this is the Constitution. No law prohibiting the exercise, typo, of religion. No law abridging the right of the people to peaceably assemble. And this is interesting, and this is what Gundy is about. All legislative powers granted herein shall be vested in Congress, right? A sheriff in North Carolina can't be making the legal determination that my client's Washington State offense from 20 years ago is suddenly substantially similar to a North Carolina offense, and therefore he's subject to a minimum of 10 years registration, along with all the other things that come with that, right? And that's not this provision, but it's a variation on the theme, right? Legislative, judicial, executive, they all have spheres. We should be looking in this context to keep everyone in their lanes. Has the legislative delegated to the Attorney General effectively the ability to make laws? That's a problem. Has the executive tried to poach onto what is properly the province of a judge? Right? Is this crime like this crime? That's a legal question. Legal questions belong to the judiciary. Right? At the same time, we've been living in a world of a shrinking of the generally accepted view of what the Constitution protects. We've been living in an era of unprecedented executive power and expansion. And I submit to you that there is an opportunity to begin to challenge that. The conservative environment takes away, but it also gives. And then just looking through. Fourth Amendment. This is a conversation that we've just been starting recently, but in North Carolina, for instance, there's a little provision of a law that no one notices that basically says the sheriff can show up at someone's house anytime they damn well please to check registration. And I don't know the answer whether that's ultimately a constitutional violation, but it strikes me as a problem, and I know what provision of the Constitution I'm looking at, right? Like, what is it in the Constitution that would prevent that? It's the prevention of unreasonable searches and seizures, right? And I would argue that if a sheriff goes to your door and knocks on it and requires you to come out and answer questions, and if you don't, can require you to come to the police station, and if you don't, it will be a felony, that is, in some sense, a seizure. He is preventing you from leaving. You cannot discontinue the conversation. Again, does that ultimately work? I don't know yet, but it starts with, what am I talking about? That's a seizure. That's the framework. That's the constitutional hook that we're going to use. Okay, and this is the hard part for me as a lawyer. Conservatism means that there is no such thing as substantive due process. And what that means is that I talked about textual hooks. I talked about how in the 60s, the Supreme Court recognized a right to privacy and then made a bunch of decisions that basically said this stems from the right of privacy. And the textual hook for that, the part of the Constitution that the court pointed to, was the part said that no state shall take away someone's liberties without due process of law. Okay. The court said, well, that's the hook, right? There are things that the government can't do, whatever the process, so there can never be due process. That's what's meant by substantive due process, that the due process clause contains substantive limitations on what the government can do. The problem with that, from a lawyer's standpoint, is that due process suggests that it's about process, right? That so long as the process is in some sort of sync with what the government's trying to do, they can do it. There really is, in fairness, nothing textual about the idea that the government can't do something without due process that allows you to extend it to the idea that therefore there's things the government cannot do. That is an intense legal battle that has been waging in various forms for 2 generations. But what it means for us today is that if you go to the Supreme Court and say that there is a right to housing, you're going to lose. I mean, I'm sorry about that. I believe there probably is a human right to housing in a society that has trillions of dollars worth of production. There's certainly enough money to give everyone housing. There's certainly enough money to feed everyone. It may be a human right. It's not a constitutional right. It's just not in today's legal environment. So going back to my first question, within the legal environment, will my position prevail? Even if I found a district judge to say, yes, I think there's a right to housing, I will eventually lose. I just will. Political reality. Okay, I talked about the fact that courts operate within the real world. They like to pretend they don't. They like to write like they don't, but they do. They do operate in the real world. And you're asking a court, when dealing with a registry issue, to do something that a lot of judges are going to be concerned will be unpopular. And if you're working in a state court, you may be asking a judge who is elected to do something unpopular. And that's just the reality. But what do you do about it? How does that shape your strategy? Well, one, provide cover, right? Give the judge a reason, a way out of just saying, I think this is a bad law and it should be struck down. And what I mean by that is facts, facts, facts. If you read good opinions, a lot of times they'll start with, a description of the plaintiff, right? And I've told you before, I'm not a huge advocate of waiting for the perfect plaintiff, but plaintiffs do provide cover, right? Facts provide cover. So when I do a petition for termination from the registry in a North Carolina state court, the petition's usually that thick because I'm just throwing facts at the judge. I throw recidivism studies. I show the studies that show that registries don't work. I go back and I get, any mental health evaluation that's ever been done of my client, the probation records. I have witnesses, all of that. And a lot of that is just providing cover. It's also educating the judge, right? But the point of doing that is I'm saying, Judge, you can do this. I've created a record that will protect you. If anyone ever asks you why you did this, you can say, well, they came in and they had the facts and they had all of this, and the state had nothing to say, so as a judge, I have to listen to the facts. Is that the whole piece of it? No, but you see what I'm talking about, right? It's always trying to give the judge reasons why that judge can rule for you and answers to criticism, right? That's what you're trying to do. You're trying to pre-arm the judge with answers to any criticism about a decision that is pro-registrant in some sense. Related to facts, 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 of course, is evidence, 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 right? Build the packet. And this is what Miriam Alkerman has said again and again. She said it last year when she was talking about her constitutional challenges. The ACLU representative from Michigan said it again today at the banquet. What are they concerned about? They're concerned about unresourced litigation because that can't build the packet, right? You have to have the evidence. You need the GIS mapping. You need the list of all the places that you can go. In Connecticut, there's a challenge going on right now, and we picked the defendant because the defendant had already posted on their website the list of places, right? It was sort of pre-done, and they can't backtrack now and say that they didn't mean all these places. But in that case, we have to get a map. We have to show where all those places are. We have to show the practical effect, and we have to get that before a judge. We cannot show up and say, well, they can't go to the library, and that's wrong in some sense. You have to overwhelm with facts and evidence. And plaintiffs. Again, I'm not an advocate for waiting for the perfect plaintiff. But if you've got a good plaintiff, use the good plaintiff. And what I'm talking about is, in the challenge we've currently got on due process grounds in North Carolina, the question is whether a sheriff can make the decision that the out-of-state offense is, quote, substantially similar to a North Carolina offense. And it's pretty clear that that decision has to be made by a judge, or at least an administrative law panel. It probably doesn't matter whether or not the plaintiff's offense is, in fact, substantially similar, right? Legally, logically, that's a separate question. But it helps that my client, it's probably not, right? So I get to go in court and say, Your Honor, I'm asking you to do something that, if it works, could have the effect of deregistering 1,000 citizens. It helps that I'm able to say, and this process gets it wrong, see Exhibit A, my client, right? That helps. If you've got that client, use it. As much as I say don't wait for the perfect client, don't give up looking for good plaintiffs. Plaintiffs whose narrative fits what you're trying to say. Plaintiffs who go back and provide cover, right? If you look at Doe v. Snyder, what does that opinion talk about? This is the Sixth Circuit opinion striking down on ex post facto grounds. It talks about the plaintiffs. It talks about the web of restraints, right? It spends a lot of time up front saying, we're doing this because we effectively have no choice. This has gone off the rails. And they do that for a reason. The court's doing it to provide cover. This is also controversial, but at least in my practice, it's turned out to be true. Play small ball. And by small ball, I mean, we have a case, and this is, I'm going to talk a little bit quite candidly about mistakes I've made. We have a case in North Carolina, Doe v. Stein, and I wanted to get the registry in front of the court, right? I wanted to be like, this is everything that's wrong with the registry. This is a big lawsuit, and we're going to go. And so the complaint is long, and it's got everything, and it's got tons of evidence attached and all of this. And eventually the judge said, look, I don't know that you're wrong, but this is too big for me. I can't do this. I can't have a case where you're asking me to essentially say that the registry is wrong in 15 different aspects. The judge in that case basically said, I'm not dismissing it. Like, no, you have a case, but streamline it for me. Help me out, right? Give me a discrete, tangible issue that I can sink my teeth into. And so in conversation with Narsal, what we're doing in that case is say, okay, look, we have 3 main problems we're dealing with in this lawsuit. There are a lot of problems, but 3 for this lawsuit. 1 is the ex post facto. 2 is the premises restriction and its application to people, who were convicted of their offense after its effective date. So it's not an ex post facto. It's just premises restrictions are unconstitutional. And then 3, as in many states, and I know there was a talk on this, in North Carolina, effectively, you can't go to church. And that's hard to get in front of a court because it doesn't say you can't go to church. It just says you can't be any place where minors regularly congregate. And I know from conversations with a dozen ministers in North Carolina that there is no church in North Carolina that meets those criteria. I've asked a dozen different ministers from around the state, are you aware of any church that does not run a youth program or a Sunday school or something? And the answer is no, because in one sense, the entire purpose of churches is to bring families and communities together. Small ball. What I took away from that case is I'm looking for focused challenges. In contrast, this due process case, 10-page complaint, focused issue, will be done in 9 months, which in constitutional terms is incredibly fast, right? But the judge could read it, the issue is straightforward, the evidence, the elements are there, boom, 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 you're out the door. Small ball. Focused challenges, technical issues. Again, you're working in an environment where it's very difficult for a lot of reasons for judges to say, this is wrong, right? It's very difficult for judges to say the state can't do this. But if you can give them technical issues, like due process, if you can give them the opportunity to say, oh, sure, you could do this, as long as you hold a hearing for each one of the 1,400 residents that you've put on the list without a hearing, that would be fine. I'm taking the bet as an advocate and lawyer that the state of North Carolina is never going to do that, right? They're not going to go back and hold 1,400 hearings, I hope. But that's what I'm trying to do. I'm trying to use the legal environment to my advantage, finding technical issues that actually have broad-reaching implications. That's not to say don't go with the ex post facto. That's not to say don't go with the First Amendment. But it is to say try to be very, very clear about exactly what it is that you're doing. And the more you can make this about legal issues, right, the more you can present these things as questions of law rather than questions of fact, the more successful I think we'll be. Okay. And the political reality, I just want to remind us, and I try to say this every time I'm given a platform and a microphone. This is a situation where we have to work hand in hand. The lobbying and the legal have to go together. Because what we can do right now in litigation is we can take, as someone put it last night, bites of the elephant, right? I can sit there in North Carolina and I can say, you have to have a hearing. I can say you can't prevent them from going to the beach. I can say you can't apply it to people who were registered before 2008, and on and on and on. You know, but I'm sitting there and I'm just, boom, boom, boom. That's what I'm trying to do. I'm trying to make it painful. I'm trying to find issues that make it hard for the legislature. And as an ancillary benefit, that stop them from trying to go further, right? I'm trying to stand up and say, if you pass this law, I will sue you immediately. Because I have access to a wealth of plaintiffs, I have experience with doing this, and I have judges that are going to say to me, oh, hello, Mr. Dubbeling, what are they doing this time? I'll be like, well, Your Honor, this is what's going on. Right? But ultimately, that doesn't result in the sea change that is ultimately the goal of this organization, right? That is intended to create an environment where efforts at getting to legislators and getting the laws changed or convincing them not to expand them in the first place is going to be more successful, right? It's intended to build up a body of law that you can show up in the State House and say, hey, if you do this, you're just going to get sued. And you're going to win. And it's going to cost you $500,000. And we're going to be right back here next year. So why bother in the first place? It's to use this to continually create the environment where legislators are actually wanting to talk to you because they know that there are issues. And then it's within that space that the real change takes place. It takes place in the state houses. In North Carolina, it takes place in the Judiciary Committee, where really the decisions about this are getting made. Okay. Adverse historical trends. Conservatism, textualism, originalism, as I mentioned, means that it's hard. It's hard for me as a lawyer, but it means that you're just not going to win, right? There's no right to housing. There's no right to employment. There's no right to intrastate travel. There just aren't. And when I say there aren't, I don't mean that in some global comment on the nature of human beings. I say in answer to my question, will my position likely prevail if I take that position? No, it won't. That's just reality. You have to point to a provision of the Constitution. But as I said, it also provides opportunities. So one is originalism says we need to look at what the Constitution meant at the time of its signing. That is the only legitimate constraint that the Constitution places, the constraints that the founders themselves would have in place. I believe that, practically speaking, that's a nonsense position, because how on earth do we know? And the exercise of deciding what Thomas Jefferson might have thought about internet deregulation seems a bit of a stretch. But roll with it, right? Because that's what you're up against. But it also means that sometimes you can go back and say, well, Yeah, I mean, parks today, not primarily for the purpose of political rallies, but they were in 1789, right? I mean, there are some great 19th century cases that talk about the right to public spaces as an aspect of free speech. And if you're talking to conservative judges, that's fair game. You're talking to a liberal and you start talking about what happened, pre the 14th Amendment, the liberal might go, listen, man, the Constitution is a living document, but it's also a dying one. Like, we're not going to, go back and say, well, because this was going on in 1840, it has relevance today. A conservative might. Justice Thomas might, right? Justice Thomas, who once wrote an opinion that said, interstate commerce effectively meant the transport of corn, and so anything that's not about corn doesn't really apply today. Not quite, but actually pretty close. He might listen to, Your Honor, from time immemorial, parks have been held aside as public spaces for the peaceable assembly of the people. This prevents them from parks. That's a First Amendment issue, has been since 1789. Thank you very much. Please tip your waiter. Might work. And it has worked, and that's what I want to say. That was the essence of Doe v. Cooper, right? I have a theory. It hasn't gotten to the Supreme Court, but I have a theory that the proper constitutional analysis of premises restrictions is under the First Amendment, because preventing people from going to public places prevents them from communicating ideas. It prevents them from receiving ideas. And that theory has been validated in the 10th Circuit and the Second Circuit. And the courts have said, the state didn't produce evidence. Usually at this stage in the game, we've won because the state doesn't believe that we'll ever win, so they don't really try, which is nice. But the courts have essentially validated the theory, which is these are First Amendment issues. And what's interesting is they're not First Amendment issues in a modern sense. They're First Amendment issues in an originalist sense. And that's why, to me as a lawyer in today's legal environment, they're very attractive. Because the Fourth Circuit didn't blink in saying, oh yeah, like you can't go to a library, you can't go to a park, you can't go to the State House. Oh, that is a First Amendment issue. State, it's a First Amendment issue, where's your evidence? State says, we don't have any evidence. And the court says, then you lose. That's good. The second thing, and this is what I've been, I hope not harping on, is you're looking for process challenges. Conservative jurists are very concerned about process and separation of powers. Who's making the decision? How is it being made? Is the process by which the decision being made legitimate? Opens up a new line of thought. The Supreme Court of the 1970s would have looked at you crazily if you brought the Gundy case and said, the problem is that the AG is, making decisions about how and when this applies. They would have been like, that's how administrative agencies work. I don't know this, but I think so. But today, a conservative Supreme Court really wants to look at that question. They really want to look at the intersection between legislative and executive authority. And if they're looking at that intersection, they're also looking at other intersections, the intersection between executive and judicial authority. Along with the legal environment, when you go into court, you're dealing with a human environment. And this is another thing I tried to touch on Friday. Follow the leader, right? We're trying to provide judges cover. We're trying to provide reasons to rule for you. We're trying to provide a good case in the sense of the word that responds to the human environment. And here, the first thing is people follow the leader. Judges follow the leader. The most effective thing you can do is show a judge that another judge has already looked at this and said that your position is correct. And I am blatantly advocating, looking around the country, finding cases where registrants have been successful and copying the hell out of them. There is no bonus point for being original, right? My hat's off to attorneys who have done original things. Glenn Girding was the attorney that actually started Doe v. Cooper, and he's the one that first said, I think this is a First Amendment issue. I helped him develop that, but that was the keystroke. But now that we have Doe v. Cooper, and we have a couple other cases, now we know First Amendment, right? Why should you be doing ex post facto cases? Because they work, right? Copy, 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 copy. Because judges will follow the leader usually. Except, you have to make sure that your case is really like the one that you're copying. And the fact that another judge did it does not excuse us from doing the work of building the case, because at the end of the day, you have to have the facts, you have to have the evidence, you have to actually build the case. The job is showing the judge that your case is this case. But if you can do that, judges follow the leader. Then this wasn't originally part of what I wanted to talk about today, but I also want to talk about how, for those of you who we talked with on Friday, I talked about how, the federal government does this, the states follow suit. One state does this, the states tend to sort of line up in order. The reverse is true, right? Follow the leader is a very real thing in the legal world. So if we're asking ourselves, what is our overarching strategy? It should be to identify vulnerable states. Because the way you ultimately get where you want to go here, I do not believe is attacking the federal government. The federal government has actually been very careful in various ways to shield itself from constitutional problems with the Adam Walsh Act and SORNA. But remember, the federal government doesn't actually matter because states run the registry. The impact of your daily lives comes from states, and states will follow the leader. If you successfully sue one state and you turn around to another state, that state is going to be inclined to listen to you. If you can successfully get something overturned in one state, other states will start to follow suit. So I envision that eventually the way we win is we ultimately convince one state to drop all the affirmative restraints and make their registry non-public, right? Ultimately, you need one state. You've got to find a leader. This is how the war on drugs fell apart, right? California gave up. As soon as California gave up, states started falling in line. And our current federal government is flipping out because our federal government has a vested interest in maintaining the architecture and consequences of the war on drugs. But if the states aren't cooperating, what are you going to do, right? If California, Colorado, is willing to say, screw it, we don't care, right? Doesn't matter what the federal government is doing, in some sense. And I want to, as I've thought about this weekend, as I've talked to people, I want to emphasize this principle. This is ultimately, to my mind, a state-level battle. But if you win in one state, you will start to win in other ones. If you can convince one state to give up, you can convince a number of states to give up. Okay. The other thing is I want to talk about judges. And there's a lot of discussion, argument, but I posit that most judges, like most people, want to see themselves as a good person, right? I don't like to go into situations presuming bad faith on the other side. In fact, I generally assume that the person I'm talking to, somewhere in their mind, has come up with a way that what they're doing is correct in some sense. I believe one of the speakers early talked about, I regret it now, but I supported full implementation of SORNA because I believed that there was a greater good, right? He did something that he acknowledges was wrong, but at the time, I had a rationalization and justification. And what judges want to do is they want to be good judges, right? No judge is sitting there, I hope not, saying, I don't care whether my decision's good or bad. I'm just going to make one and go get lunch, right? They want to be good judges. Everyone wants to be good at their job. We can assume, despite the rare exception, that the person we're talking to wants to be a good judge. And what that means in this context is a good judge wants to be consistent, right? They want their logic and their reasoning and their opinions to be correct in some sense. And they want to uphold the law. And one aspect of conservatism is the belief that there exists a thing called the law. That in a given case, there is a right answer, given the precedents, given the facts, and what have you. And that if you spend enough time and attention, you can reach it. It's philosophical discussion whether or not that's legitimate, but that's, for your consumption, that's what judges are generally trying to do in a positive respect. They're trying to uphold the law. And also, people like stuff to be easy, right? Of course people like stuff to be, I like stuff to be easy, right? And so when you're framing a case, the human environment says you want to lay it out for the judge. You've got to show this judge why the law supports your position. And you can reach back as far as you want to do that, and you've got to make it easy. And frankly, this is a mistake I made in Doe v. Stein. I didn't make it easy. It was all there, but I didn't walk the dog for the judge and say, Your Honor, boom, 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 conclusion, there we go. We're fixing that. I did do that correctly in the other case, Meredith, and that went much smoothly, because if you can present a case that's straightforward, simple, and you can demonstrate that the law supports your position, judges are going to be very sympathetic. And they're going to be sympathetic because they're human and that's what they're looking for. Okay, I've got 10 minutes left, so I'm going to start speeding up just a little bit. Okay, practical challenges, things to look for, ex post facto. Ex post facto challenges have ancillary benefits because if you can convince a judge that this law is ex post facto, that judge has just made a factual ruling that that law is punitive. As soon as a law is punitive, it is easier, and this isn't a straight line. It's not if you win ex post facto, you win this. It is easier to talk about due process challenges, right? It's easier to say, Your Honor, this is punitive. We've already decided that. So why on earth is this being applied indiscriminately? Right? It is easier to talk about First Amendment issues. Your Honor, this is punitive. Clearly, we've already decided that. So how is it not illegitimate that they're keeping them from all the public fora in the town? Right? Ex post factos are great cases. And the key to an ex post facto challenge is, has the state established a system of affirmative restraints? And specifically, does it look like probation? That's what I believe to be the strength of the North Carolina regime, is they've essentially recreated probation in the registry laws. And the finding that's critical to an ex post facto challenge is that this is a historical system of punishment. So what I believe you can do is say, probation is certainly a historical system of punishment. It's actually part of the sentence. This is exactly like probation. Ta-da! Okay. Okay, due process challenges. This is what I was talking about. Who's making the decisions? How are the decisions getting made? The scope of liberty interests protected by the due process is much broader than the scope of constitutional rights protected by the Constitution. A liberty interest is everything that the state allows ordinary citizens to do, right? Being subjected to a sheriff coming to your door to check on your residence, that is a deprivation of a liberty interest. Being prevented, being required to go to the sheriff's office, deprivation of a liberty interest. Being impacted in your ability to go to public places, absolutely a deprivation of a liberty interest. And when you've got liberty interests, are they being taken away without hearing and an opportunity for review? Right? And you have to be careful. If the registry is a direct result of the conviction, if you live in a state where saying you were convicted of this crime and therefore you're on the registry, you're not going to have a due process challenge. That's what was foreclosed in 2003 by the Supreme Court. But in North Carolina, and I'm guessing in a lot of other states, there are a lot of other ways to end up on the registry. This decision that this crime in this state is like this crime in our state, right? It's not a result of the conviction. A separate determination has been made. You should get a judge for that. A decision about whether particular provisions of the registry apply in some states, these systems. How is that decision getting made? Okay? You're looking for instances where some determination beyond the fact of conviction is being made, and on the basis of that determination, rights are being taken, well, not rights, interests, liberty interests are being taken away. Okay? If you find that, call me, please, because that is a due process problem. Separation of powers, this is what I'm talking about. Who's making the rules, right? Look at your state statutes. Who's making the rules about registrants, right? Is it really just the statutes themselves? Or do the statutes, like in North Carolina, say things like, the sheriff can check on registrants in the sheriff's discretion, right? That's not a rule. That's allowing the sheriff to make a rule. That's a separation of powers issue. First Amendment, talked about this last year. The beauty of the First Amendment is if you can frame a First Amendment challenge, the state has to do more than come up with some plausible reason. The state affirmatively has to demonstrate that this law is reasonably related to the threat. And there are a string of cases where when the state is said, you have to show that this law is narrowly tailored to serve a substantial government interest, the state can't do it, right? There are multiple cases, including Doe v. Cooper, where as soon as a court has said, state, you have to make an affirmative evidentiary showing, meaning you have to give us facts that support this law, we win those because the state doesn't have the facts. Key, are people being banned from public places and or private gatherings? Are there premises restrictions? Are there internet restrictions? For purposes of the First Amendment, the internet is a place that you are allowed to go. Okay, general litigation strategy. Look for ex post facto claims. I said they're viable. A number of courts have upheld that. I think it's 8 or 9 states now, plus the Sixth Circuit. If you're looking at an ex post facto claim, consider carefully whether you want a federal or a state claim. And if you're looking at an ex post facto claim, please contact my office. I will be happy to discuss in your particular circumstance which one of those looks better. But that's an issue, federal or state. Resourcing. NARSOL has been working on this, and I just want to reiterate the call. We need to look to building a more unified repository of law, facts, and studies. For the past year, I've been doing this, but we need to find a way to integrate that so that the evidence, the facts, are more readily accessible. I've also talked to some people about this, and this is a personal opinion. If you have a valid constitutional claim as an attorney, I should be doing that on contingency, basically. I get distrustful of attorneys that are soliciting money to pay their fees to bring constitutional challenges. But constitutional challenges are expensive because you need the experts, right? You need the studies. And to the extent that that is how Doe v. Snyder was won. They commissioned experts. They commissioned studies. They proved their case. So if we're looking for ways to fund things, I suggest, and this is not, let me be very clear, this is not a NARSOL-approved position. This is just me as the speaker saying, where is funding needed? In my world, funding is needed for experts and studies. I need facts. I can do the law on my own time. I can donate my time. But what we need is we need to be building the factual record, because that's how you win cases. And look for process claims. Process claims are cheap, frankly, because they're not fact-intensive. And they're great ways to sneakily try to get lots of people off the registry. Sneakily is probably the wrong word there. They have the ancillary benefit of being very clear and applying to one person, and then you turn around and they apply to 1,000. Okay, last point, and I'm running out of time here. Litigation has limits as an agent of change. The lawyers can't garner the big win. They just can't. Not in this legal and human environment. But litigation is a powerful adjunct to lobbying efforts. What lawyers can do is they can create the conditions for favorable political change. And today, there are distinct opportunities for success. But I'm asking us to recognize the reality that we live in a conservative world. And I made this point last year. I've refined it, I hope. We live in a conservative world, but that just means that we have to consider our legal strategy with respect to that environment. It doesn't mean there's not a viable litigation strategy, but we need to know that reality, we need to work that reality, and we need to recognize that as much as there are things that we're not going to be able to do, there are things that we are. Okay, thank you.